Good afternoon, everyone. My name is Chris Pon, and I'm the VP of Fund Development at ALS Canada. Thank you for joining our webinar today. Today, nearly 4,000 Canadians are living with ALS. At ALS Canada, we're determined to transform the reality of this disease. We do this by working with the ALS community to improve the lives of Canadians living with ALS by advancing research, advocacy, care, and information. Thank you for joining us on our webinar and our journey to a world free of ALS. November is Make a Will Month and highlights the importance of having a will in place. In our first webinar, this past May, we talked about the basics of setting up a will. And based on feedback from our participants, today's topic was selected on selecting an executor. So by selecting an executor or being named an executor, it's an honor, but it also comes with lots of responsibilities. So we hope today's session will provide you with insights and information you're looking for as you select an executor. Before we start, let's go over some housekeeping rules. Today's webinar is being recorded. There will be a Q&A session after the presentation, but if you have any questions, feel free to pop them into the chat. And there's no need to take copious notes. Take what notes you want, but we'll send you the information and the recording of the session after it's done. So now we will start, and I'm pleased to introduce our two powerhouses and our friends from Concentra Trust, EQB Bank. I'm excited to welcome back Jandy John, Director of Estates and Trust, and also her colleague Rachael Osho, Senior Estates and Trust Coordinator, to take us through today's presentation on the power of selecting an executor. So with that, I'm thrilled to pass it off to both of you.
Thank you, Chris. Thanks for having us here. And we know last time we talked about the importance of having a will, and we shared that about 50% of Canadians do not have wills, so it's Make a Will Month. What I want to talk about right now is the importance of choosing the executor, and choosing an executor is one of the most consequential and important decisions in your estate planning. And keep in mind that when that choice is being made, it should not be done with feelings or family ranking. The appointment of an executor in Ontario, we call it an estate trustee, is appointing someone who is trustworthy, someone who's competent, someone who's neutral, someone who's never declared bankruptcy, and they have to be of age of majority. The person appointed should follow the terms of the will and to carry out your last wishes with care, diligence, and good faith, and not to their interpretations of what should happen. So let's talk about who we are first, and then we'll jump right into it. So my name is Jandy John. I'm Estates and Trust Director at Concentra Trust. I have many years of experience within the industry. I don't want to say the number, but it's many years. I work with Canadians, high net worth, ultra high net worth, and Canadians in general to help with their estate planning, powers of attorney guardianships, and I like to empower Canadians to do their estate planning, because the consequences of not planning is costly and it takes a lot of time to administer estates when there's no plan in place. So now, Rachael, if you could introduce yourself.
Thank you for the introduction, Jandy, and for the quick recap. My name is Rachael. I am the Estates and Trust Coordinator. So I assist clients through the onboarding process and also manage the transition of files. Onboarding can be a long process, and it could also be a bit tedious. So we're here always to assist through that process. And that is my role at Concentra. Okay.
So what are we talking about today? So today, Rachael will do a recap and talk about wills, and I'll be talking about executor, different kinds of executors, and finally appointing an executor. So I'll hand it over to you, Rachael, to start about wills.
Okay, perfect. So when we're talking about wills, one of the first questions that usually come to mind is, why do I need a will? And as Jandy had mentioned, it's very timely that we're talking about this in this month of November, which is the Make a Will month. And it turns out that we still have about 62% that studies show adult Canadians do not have a will. And so it is such an important it's such an important document that everybody should have, but we still have about 62% Canadians that do not have a will. And so when we're talking about a will, we do have a little quiz here. There's more than one answer. We just wanted to get our audience's understanding of the topic. So what happens to your assets if you were to pass away without a will? I'm going to give about 30 seconds to get your responses, and we'll have our host share the answers. You should see the poll. Perfect. We're getting some responses. Perfect. Okay, still going. And I believe everyone can view the results as it's coming in. Yeah, I'm going to give it 20 more seconds. Okay, and I will be ending the poll in about, okay. Yes.
Oh, very even.
All right. Oh, these are really good responses. And it makes me know that we're speaking to an audience that does have an understanding of this topic. So what actually, and thank you all for your responses. Okay. I'm just gonna get the result of my screen. Perfect. So what actually happens when an individual dies without a will? And in the estates world, it is called dying intestate. There are a couple of things that happen. Your assets could go to your family members, and that's if the deceased did have family members in Canada. And if there were no family members in Canada, the government could eventually take over. Okay, on to the next slide. So as I mentioned, just to give you a better understanding of what happens if you were to die without a will, the rules of intestacy are different per province, and we're just going to use the province of Ontario. In the province of Ontario, if you were to die without a will, there are a couple of things that could happen. But first, let's talk about 3 reasons why you need a will. You get to decide who will be responsible for handling the affairs of your estate. You get to decide how your assets are distributed, and you get to save money during the process. This is just amongst a number of things that could happen if you had a will. And it also guarantees you peace of mind because you had taken the time to plan ahead by creating a will. On to the next slide. As I mentioned earlier, there are laws that are put in place in every province, which are called succession laws, that determine what would happen if an individual was to pass away without a will. And those laws determine who would also manage the affairs of your estate. So what happens is that a family member or any individual who is related to you can apply to the courts to be appointed as the executor of your estate. Unfortunately, if you did not have a will, you did not decide or could no longer decide who can put that application forward. And there are also tax planning strategies that could have been put in place if you were to have a will, but if there was no will, then the province does not know, what planning strategies that you may have wanted to have in place, and they determine what happens and how your assets are distributed. If there was an individual, say a family member, that put in an application forward to take on the tax of being your executor, then they would be the ones to determine if they were to be appointed by the court, they would be the ones to carry out the administration of your estate. Also keep in mind that in the province of Ontario, common law partners do not have automatic inheritance rights. So that's something to keep in mind if you were to pass away, leaving a common law partner behind. Next slide. How would your assets be distributed if you were to die without a will? So there is what we call a table of consanguinity, which kind of determines the closeness of the living relatives to the deceased. First, they would consider the spouse. If there were children, it would be the spouse, and next, the children. If there are neither a spouse or children, they would consider the next family members, which are parents, siblings, nieces, and nephews. If there are no living family members, as the poll result shows, then the government will take over. And that is not a situation where any individual would want, because then you didn't get to determine how your legacy was passed to the next generation or to any living descendants. So why is it important to have an estate plan? There's so many benefits to having an estate plan. And at the top of mind, it's protecting your family members, protecting your spouse, any minor children, your loved ones. When you have an estate plan, you control how your assets are distributed. You control who gets to take on that responsibility of managing and distributing your assets. You have the authority to decide who is the executor of your estate. And they also, during the planning process, you also get to avoid all the tax implications and the cost of probate. On top of that, you're able to support if you plan to give charitable gifts to any charity donations, you would have had the opportunity to do that while you were putting your will in place. And that ties into succession planning. So you kind of have the ability to have a bigger picture of your assets and how you wanted them to be distributed, who takes on the responsibility, and how you wanted to cater for family members. Yeah, so that's just a little discussion on naming an executor, why it's important to have a will. And the next couple slides, Jandy will be talking about being an executor, and I'm just going to hand it over back to Jandy.
Thanks, Rachel. Thanks for the summary and the recap of the importance of the will. Now we're going to talk about being an executor and what that means. We'll lead it off by doing a poll to see, so you can pull the poll up, Rachel. The question is, who can finalize your estate if you die without a will? No one, family members, or the government? I'll give you a few seconds here. Okay. Okay. Perfect. So it's a split between family members and government. I see that no one is choosing no one. So that tells me there's some information there. So let's give the answer. So let me end the poll and we can go back to the webinar. Okay. So we have 56% saying the government and 47 saying family members, and correct answer is government and family members. So that was a trick question, everyone. So let's get into exactly who can be appointed when there's no one named. Rachel, can you go to the next slide? So in terms of who can be appointed, there's a rule of thumb in who can appoint, and at the center of that rule are the beneficiaries. The beneficiaries has to consent to anyone or any entity that will be appointed, and it's a court application that is required. So for example, if ALS is a beneficiary of an estate and there's no executor appointed, then ALS will have to consent to anybody or anyone that's going to be appointed. It is a long court application, and it does cost money to the estate, and is time consuming, especially if the estate has multiple beneficiaries and if beneficiaries are outside the country. So it's very important that when the will is being drafted, the consideration should be done in terms of who the executor and who the trustee is. And also, if there is no will in place, then it becomes more of a long-standing process to determine who is going to administer the estate. My longest example of that is we had about 50 different beneficiaries around the world, and it took about 2 years to get the consent of the beneficiaries to get a trust company appointed to be the executor. So when we talk about being an executor, let's talk about how to consider appointing someone. So if we could go to the next slide, Rachel, we'll talk about what is an executor. So an executor is a person or an entity appointed in the will to administer the estate. So appointed in the will does not always mean that that's the person that's going to sell the estate, because an executor named in the will, they do not have to accept that appointment upon death. That decision is made at the time of death and the time to act. So that's why it's really, really important to let the person know that is named in the will that they're named, and they will know what is expected of them, and they'll have an anticipation. So when that time comes, they will be ready to act. The name executor must also put the beneficiary's interests ahead of their own. They need to avoid conflicts. They must show transparency with their accountant, meaning that report of transactions in the estates must always be sent to the beneficiaries, while they have to administer the estate prudently. And that is sometimes tricky, particularly sometimes estate executors are also beneficiaries. They may also have reporting within businesses that is owned by the estate. So wearing multiple hats can change decision-making process. So consideration for the executor or estate trustee in Ontario needs to be considered. There are other roles within the role of the estate. So picking the wrong executor can also be very, very costly for time and also for money spent on the estate. So what are the challenges now of being an executor? Okay. So there are many challenges with being an executor if it's not done correctly. You can choose one or more executors to act, and that's called being co-executors. So if there's 2, 3, or 4 executors, that's the co-executor relationship. Co-executors can sometimes be very useful in complex estates administration. However, appointing one or more executor has a lot of very unique challenges of its own. For instance, when collecting assets of the estate, banks and other financial institutions may require signatures from all of the executors. And if one executor doesn't have mobility or they're not in the same location, that can be very challenging. However, as co-executors are named, there's also, when you name co-executors, they can also put in the wills that how the executors can act, whether unanimously or majority rules. If a trust company, for example, if a trust company named in a will with multiple executors, we like to see a majority rules where the majority of executors will make that decision. Also, there's executor can be permitted to certain decision making, like if there are multiple executors, you can specifically state in your will that Executor A can sign documents for the banks and for real estate. So that can be put into your will if the decision is to have multiple executors. There has to be clear written decision-making rules at the time when you're picking your executors, and let the executors know what the rules are that's outlined in the will, and always give a copy of your will to the executor's name so they can know. They can have it and know where the original will is being kept, so when they're called to act. So we'll talk about time drain. So being an executor, we all know, takes time, and it's a full-time commitment to act. Administering even a relatively simple or small estate can take months or years, and it depends on what the wishes are in the will, whether that estate is paid directly to one person, 20 people, or whether it's a continuing trust for someone with a disability. So it does take time, it does take considerable amount of time drain for an individual to do it. In last presentation, I did say that a state administration has about 260 to 300 individual tasks. So think of an executor who has full-time commitments, taking care of all those tasks. I also give an example of an executor who lives out of province. Travel may need to incur because of property access. There may be meetings or court filings. So you should also be realistic in your potential executor's life. There may be caregivers, they maybe have professional demands, and they need to meet the commitment of being an executor. So executors also carry personal exposure for mishandling of estate. That's where the personal liabilities come in. So delays in paying taxes or creditors, failing to preserve assets, selling below market value, or poor record keeping, or acting with bias can also trigger claims by the beneficiaries and by the Office of the Public Guardian Trustee. And Office of the Public Guardian Trustee will be involved if there are minor beneficiaries involved, if there are charities involved. I have a situation right now where charities involved in this estate has been open for about 8 years, but the charity is not receiving the gift that was left to them under the will. So now the Public Guardian and Trustee is involved to ensure that the charity receives those gifts and ensuring that the executor is liable. Currently, the executor has to pay back the estate about $250,000 because of mishandling of funds. So when saying that, the proposed executor should know the seriousness of the role and understanding that they do wear a fiduciary hat. They must be willing to seek professional advice when needed, like lawyers, accountants, appraisers, realtors, and commit to timely administration of the estate. Above all, an executor must and always must report to beneficiaries, because the beneficiaries can challenge the actions of the executor and how the executor spends the estate's funds by engaging lawyers and accountants. We don't want to see a lot of self-dealing in the estate. We don't want to see any self-dealing in the estate. And should any beneficiary be successful in any challenges against the executor will be out of pocket for those expenses, because that's the role of the executor, is to preserve the estate. Rachel, next slide, we can talk about some liabilities of the executor. So we talk about some of the challenges and we hit on some of the liabilities to the estate. To be specific, I want to talk about what personal liabilities for any action taken to challenge by the executor. For example, if an executor did not advertise to creditors and a creditor comes forward 7 months later, if the executor did not pay the taxes owing by filing the appropriate tax returns, if an executor distributed funds that did not belong to the estate, or if then they're personally liable for any of those actions. So how can an executor limit those liabilities? There are 4 ways that can help an executor to limit those liabilities. One being to advertise for creditors. When we advertise for creditors, back in when I first started in this industry, advertising to creditors was advertising in the local newspaper where the deceased lived, and that would run for 3 to 6 months, and it will give a time frame for when these debts can be collected. And if a debt was known, the creditor would approach the executor and any claim. After the expiration of that timeline, any debt coming to the estate would not be quote unquote valid. There'll still be disputes, but the creditors will be hard pressed to get that money back from the executor. And that timeline is typically 6 months after the issuance of probate. So that's why probate is important too, is to help with the collection of debts and the advertising. Another method is to obtain clearance certificate from CRA or Canada Revenue Agency. And what that is the final stamp from CRA to say all the taxes has been filed and there's no taxes owing, and it's the final say to say you can distribute all of the estate. CRA has been known to come back years later to say they did an assessment. But once you get that clearance certificate in your hands to say clearance certificate for final distributions, they're very hard pressed to get anything back unless, as an executor, you misreported any assets. Thirdly is to keep the beneficiaries in the loop. I've not said this at many different points in this presentation, but that's really important because the beneficiaries are the center. They are the recipient of the funds coming to them. So they have a lot of control in terms of what they can challenge or not challenge. So keeping a beneficiary in the loop at all the major junctures when bills are paid will help the executor obtain their releases. And what that release does when they receive it from the beneficiary is to say, hey, executor did a great job. I saw all of your accounting. I'm going to sign off to release you from all the duties because you reported to me and I knew exactly what was happening. I knew the cost for the lawyers. I knew the cost for the accountants. So I'm happy with your filings. Here's a sign off and it's all done. So those are ways to avoid those liabilities as an executor, is to ensure that you report an account correctly. So I want to go to considerations for appointing an executor, and then I will wrap with a scenario with a live person, and then we can decide how to choose an executor. So one of the first points, and it's not on this sheet, is location. When you appoint an executor, consider the location. It is generally preferable to choose executor in the province or at least the country. Local executors will have an easier time dealing with personal assets, selling real estate, and potentially accessing bank accounts. But further, out of province or non-resident executors may require to post an estate administration bond as a condition of probate. And what the estate administration bond is a court-approved guarantee typically issued by a surety insurer or qualified personal sureties, and it is intended to protect the beneficiaries and creditors against any potential loss or improper administration by the executor. The bond is based on double the value of the estate, and the cost per bond is 2.5, the range of 2.5 to 2% of the value of the estate, and it's charged to the estate. The posting of a bond does cost money to the estate. It does cause delay, and it does add a complexity to the estate. So choosing local executors does avoid these issues. And we have seen in many wills that there's a clause that there's no bond required, there's no necessity to post a bond. However, this is no guarantee that the court will abide to this clause, especially if you have beneficiaries that are minors, beneficiaries that are charities, beneficiaries with disability. The rights of those beneficiaries will be protected, so the bond will be required. The dynamics, executors should be aware of the appointment. Again, we said that appointment is in the will, but they start to act in acceptance upon death. And they need to understand the family dynamics and what the role is and how they fit into the family. So with family members, often spouses and children are most commonly appointed executors, though this is not always the right choice and right decision. The role of an executor is not easy, and it can be very overwhelming to some people to deal with. So when you're appointing your executor, ask yourself these questions. Can the family member be able to manage your affairs, particularly while they're grieving? Do the family members all get along? Ask yourself, do family members, if acting in co-executors, can they act together, or is there one person that we can choose to act? Ask yourself, if you have a blended family, will the current spouse treat your children from previous marriage the same as children born from the marriage? And also, could a spouse or could the family members adequately handle any business interests? Because if there's a business interest, can they take over and step into your shoes as executor to manage the business, and how will the business wind down after your passing? Family members should not always be appointed, especially if it's based on feelings or concerns that one child or one sibling is going to feel left out. Sibling rivalry, again, are difficult relationships, are very, very, very real and can lead to long-lasting relationship damage. In my many years of administering estates, I can say that I've seen a lot of family dynamics because the parent is no longer alive to mediate between the children, and that becomes very contentious upon death, and all grievances will come forward. The executor really has to be a psychiatrist also, because they have to deal with family disputes and everything that happens. And again, when that happens, it cost to the estate because of litigation. How to mitigate that? I tell people that corporate executors and professional executors may sometimes be the better choice than family members. Even me personally, had conversation with my family, and because I do this for a living, and within doing this, I think I've administered tens of thousands of estates, and I've said to them, no way, do not even ask me, I will not do it. Because again, it's the commitment of doing it. It's not always the most thankful job to do. So if you're going to appoint a family member, I would encourage you to talk to your family members and emphasize that your choice is not based on love, but who will be the best person or persons to do the job. Consider the family members, are they local or do they live out of country? Do they have the expertise to manage this? Or do you want to put a team around your family member, or do you want the family member to act in accordance with trust companies or professional executors? So the bottom line of this whole slide is choose your executor with your head and not with your heart. Pick the person or team that is likely to preserve the estate value, treat beneficiaries fairly, meet deadlines, and keep meticulous record, because there are specific deadlines to be met in estate administration. There are tax filing deadlines, there's creditors deadlines, so ensure that they know the deadlines and they can meet those deadlines. Well thought out choice now concerning the executor is the best way to ensure your wishes are honored and save loved ones the stress and financial cost of litigation later. Okay, next slide. We touched on this before, and I want to bring it up again because appointment does not always equal acceptance. So naming someone in your will does not always mean they will sell the estate. The name executor can renounce, meaning they can refuse to act. It is in the event an executor name is also predeceased, the will maker refuses to act, is an imperative that you name an alternate executor. And an alternate executor is, again, you name A, and if A, and the will is specific, if A cannot act or refuses to act, then B steps into the place of A. The rule of thumb also is to review your will and select an executor and alternate executor periodically. I usually recommend within 3 to 5 years, or a life-changing event. Life-changing event being marriage, divorce, death of a person, death of your executor, age of your executor, to keep it current, and also ensuring that that executor knows your will, knows where the original will is kept, and has a copy of it if action is required immediately. So if there's no will in place, we covered this slide previously, is who is going to act. And again, if someone is chosen to act, or a trust company or a professional, it has to be approved by the beneficiaries. That person can act, or also the beneficiaries can act in themselves to settle the estate. Okay, so next slide, please, Rachel. So we're going to talk about a consideration, and we'll present this as a will maker and give a synopsis of the will maker. Then we'll go through some choices and give some pros and cons. So let's talk about this specific will maker. The will maker is retired. He's over 70 years old, recently been widowed. This will maker has an older sibling, has 2 children. Both children have families of their own and in the prime of their careers. One child lives out of country and the other child lives in the neighborhood. The will maker has a great relationship with his children, but his children are estranged from each other. So who should this will maker appoint as his executor? So let's go through some pros and cons of who and why. So let's start. Let's consider the will maker thinking about the pros and cons. He has an older sibling, so he can say, okay, I want to name my older sibling and my child that lives in the country. The pros of this decision is there is no requirement to post a bond. And if his sibling predeceases him, the will maker, then the child can take over to continue to act because the name is co-executors. Even if the child was named as alternate that lives in the country, you can just take over. But keep in mind, if the child is named as an alternate executor and the sibling started the administration and died during the administration, the executor's executor, the sibling's executor will take over because he started the administration. So the alternate cannot take over if the estate administration started. I hope that makes sense. Makes sense in my head. Okay, so the cons of appointing the older sibling and the child that lives there, I just said the one there. If the older sibling is the executor and passes away while alive and the child is the alternate, then the executor's executor will take over. Multiple executors also can slow down administration and because of mobility and other concerns, and also the children do not get along. And when that happens, there's mistrust and miscommunication, and it adds to the complexity and it could lead to litigation. Let's go to a second scenario. The will maker can appoint the sibling and the two children. I see no pros in this scenario whatsoever, appointing all three. There's confusion, there's an out of country executor. Executors do not get along, the age of the sibling, if he takes over and starts to act. The children do not have time to settle the estate because they're in the prime of their careers and they do not have the time or expertise to do so. And even if they all act, the coordination of out of country executors is very problematic, especially if the will does not have unanimous clause or doesn't have majority clause or doesn't have any of those clauses that would allow that. And if it does, there may be a requirement to post bonds because of one non-resident executor. So I see no pros in all three of them acting. The will maker can appoint the two children, same scenario, out of province, out of country executors, and the requirement to post bond may come into play. There is mistrust between the beneficiaries, and the coordination to get things done may not always be done in a timely manner. So another scenario is appointing the child that lives in Canada in the neighborhood. And there's a lot of pros to this selection in terms of there's no requirement to post bond, there's a local representation, and they can be done relatively easy at an administrative point. But from an emotional side, there is the con of does one child see favor in one over the other, and they do not get along with the mistrust. So the reporting to the non-resident beneficiary may be problematic. Again, these can be sorted with conversations while you're alive, but those conversations have to be very honest and why it is being done. Personally, I see the ultimate choice for this will maker is appointing the child that lives in Canada and an alternate being a trust company or a professional executor. So when the task comes to the child that resides in Canada is to say, am I going to take this or am I going to renounce or am I going to act? And if the choice is to renounce, impartiality of the trust company is there as the alternate to step in to act. Ultimately, they can say trust company and leave the children out of it, and the trust company or professional executor can take over to ensure the wishes of the will maker is carried out. Okay, so Rachel, I'll put you on to continue with corporate executors and any benefits of appointing corporate executors.
Thank you so much, Jandy. I know that was quite a bit of information, but I hope that all the details and information that was shared was taken with a lot of understanding. as to the benefits of working with a professional executor. As in the case of that scenario that was mentioned, if that will maker had appointed a professional executor, professional executors have perpetual existence, meaning that they stand the test of time. They do not get deceased as an individual. So if that will maker was to only appoint his older sibling, the expectation would be that the older sibling passes um before the children. But then what happens if just the older sibling was named? If a professional executor was named as an alternate, then that professional executor can take over the estate administration task. So I'm just going to go through the list that I have here, and there are a lot more benefits to working with a professional executor. Top of list would be that a professional executor will execute your estate plan according to your wishes as they are outlined in your will. A professional executor ensures that the day-to-day administration of your affairs are done again in accordance with as is listed in your will. Professional executors maximize the chances that your assets will be transferred as you wish, and how your legacy is transferred should be your choice to make. And so a professional executor will make sure that your desires and your wishes is exactly how your assets are distributed, as they do have that fiduciary responsibility to ensure that your wishes are carried out. Next on the list is professional executors have the expertise. Most professional executors know how to manage the administration process from start to finish because they understand the importance of going through each step and going through it in a timely manner. As Jandy mentioned, there are some deadlines, and it could be to the detriment of the estate if those deadlines are skipped or not carried out properly. Next on the list is your financial affairs are managed efficiently with the best interest of your beneficiaries. Ultimately, the goal of a professional executor should be to ensure that the wishes of the interest of the beneficiaries are not dismissed as it relates to your estate. So if a professional executor was to take over, the beneficiary's interest should be at top of mind. And if there was anything that was to happen contrary to how it was stipulated in the will, the beneficiaries should be ultimately carried along. And if anything was to change or whatever the scenario is, beneficiary should always be involved in any of those changes. So next on the list is appointing a professional executor removes the emotional and administrative burden from your family, which is a very important point because family members are usually grieving the loss of the deceased, and the last thing on mind should be, you know, what is next? How do we administer this person's estate? It would have been a lot more burden taking off from family members if there was a professional executor that is managing the financial affairs of the deceased while they're focused on the loss and grieving process. It could be a very tedious and time consuming task that could elevate the stress off from family members. Next on the list is professional executors ensure that your financial affairs are securely managed now and in the future. Again, in that will, it all contains the wishes and, you know, a professional executor is our main role is to ensure that those wishes are carried out. And lastly on the list is it gives having a plan gives you and your family members peace of mind, and that peace of mind carries through even into, you know, how the family continues while you're away or after your passing. Next on the slide, I have things to consider when naming a professional executor. And Jandy did touch on a couple points on this list, is if you do not have any family members or friends in the jurisdiction, it would be prudent to consider a professional executor, knowing that there was no one that could take on that role if you were to pass away. A professional executor can also be named as an alternate executor. So if person A was not able to act at the time or was looking to renounce the appointment, because appointing an executor does not equal acceptance, as it was earlier mentioned. And so if that executor chooses to renounce, the professional, the second alternate or the second named professional can take on the role and step in as executor. If you have any complex family dynamics, it is very important to consider, for the sake of peace and harmony, a professional executor. Again, when there are complex family situations in a blended family setting, it might be difficult to place one person over the other. And that's where a professional executor can help relieve that stress and that burden off of the family members. And lastly, if there are complex asset structures, say there is a business involved, or you were to own private shares or a holding company, professional executors are seasoned professionals, and they would know how to manage those business assets. And also, even if there was a need to involve um, other professionals like an investment advisor, an accountant, professional executors usually have those relationships where they can involve other professionals in the administration of your estate. Okay, so that was a lot of points to go through. The next slide here is a disclaimer that I will allow Jandy to kind of go through.
Okay, I'm not going to read the whole disclaimer. Typically, this webinar is for information purposes. It is not to provide legal, accounting, or investment or financial or other advice. If you intend to do your will and need, I would recommend you talk to your lawyer, your accountant, and your financial advisors. And that's the disclaimer in a nutshell. And it will be presented to you when you get the full presentation also. So we can go, if there are any questions or any comments, we would love to take those from you now.
Well, thanks, Jandy and Rachel. That's a lot of food for thought there.
A lot.
Being an executor sounds like it's a job in itself. And really, as I said to you, makes me think about my position as well. So we have a few questions. I'd encourage anyone who is on the call. There is a chat icon at the bottom of your screen. If you do have any questions, throw them in there now. But I'm going to start off with a few, Jandy and Rachel, and some of them might be repetitive, but as I learned in school, it's better to learn and repeat because it sinks in more. But the first question is, what is the role and responsibility of an alternate executor, and what is the difference between alternate executor and a co-executor?
Okay, so an alternate executor is someone named after the main executor. For instance, if I am named as executor and if I cannot act or renounce, there's an alternate name. Rachael is named as alternate. So if I cannot act, Rachael will be the alternate and step into those shoes. So that's an alternate executor. A co-executor is named to act together. Like the will state, I will name Jandy and Rachael to be executors and to act jointly as executors under my estate. So decisions are made together. Alternate is after, if the executor cannot act, and co-executors, they act together.
Perfect. Oh, go ahead.
So I just wanted to add another part of that question was if the roles change, and just to give a point that the roles are the same. If the co was to come in, the roles don't change. They do have to deliver that same fiduciary duty as if there was a first person that was acting as executor, the second person does have to continue that same responsibility.
Right, thanks, Rachel. I have a timely one from someone here. So I've been named an executor. What are my first steps after the person passes away?
Okay, the first step is to secure the will to ensure that the will is the last will in place. Because so location of the original will is the first step. The next step is to ensure that the assets are secured. And once that is done, it's notifying the beneficiaries. First step is acceptance. I accept the role as executor. I'm going to locate the will and I'm going to represent the estate as executor, and then secure assets and assets are in place.
Right, thanks, Jandy. I have this question as well for myself that just came in. So what is the general cost for a professional executor? Is it based on the size of estate or percentage? And kind of a second part to it is, how do I find and pick a professional executor?
Okay, Rachel, I'll take that, or you can jump in. So executors, professional or non-professional executors, can charge up to 5% of the estate value. So the courts will allow up to 5% of the estate value. And when you submit your cost to court, it will be based on different variables, complexities, and otherwise. A professional executor will charge anywhere from 2.5% to 4.5%, again, based on the complexities of the estate, because typically trust companies and professional executors will have tiered rates based on the value of the estate. So you'll get cheaper costs from a professional than an individual if they want to charge a fee. To start the conversation and choose an executor, and if it's a professional executor, I would say interview 2 or 3 different services and figure out what's the best fit for the family need and for yourself. A lot of bank-owned trust companies want to work where everything is at the financial institutions, and there's some trust companies that can work if assets are outside in a different location. So it's an individual choice, is to choose what feels good for the family and who you can work with and who makes the most sense in terms of what the estate looks like in complexity and value.
Thanks, Jandy. Another question, our favorite people at CRA question. So does CRA provide all required forms, and is there a single contact to obtain the needed forms?
For CRA? No.
Yes.
No. CRA, there is specific things you need to file. First is the date of death return. And the date of death return is due April 31st or 6 months after date of death, which one is the latest, whichever date is the latest. So the first one is obtaining date of death return. For some estates, there may be other supplemental returns that needs to be filed. An executor should also get any medical receipts they have or things like that that can reduce the debt load, or knowing what is registered and things that passes outside of the estate that can play a role in the T1 date of death return. So if you go on the CRA website, you'll probably see date of death return and T3 return. The T3 return is the actual estate return, and that reports income to the estate from date of death to date of distribution. And typically in estate administration, you may need to file minimum two T3 returns. And once the T3 return is done and a notice of assessment is received, that's when you can approach CRA for your notice, your clearance certificate. In some cases, executors will ask for a clearance certificate for the T1 date of death and for the T3 return. So there are 2 different ways to ask for the clearance in those, but the strongest clearance is the T3 clearance for final distribution that everyone should obtain before they do any final distributions. So bottom line, CRA website may have some general notes that you need. There's not one specific person that you can contact. It's on the web page, but if you have an accountant that is doing the estate returns for you, there will be the contact to CRA to keep it at one point.
A follow-up question to that, Jandy. If they do have a professional executor, do they take care of all this administration with CRA, et cetera, et
Correct.
cetera?
They should be taking care of everything because after taxes are filed, the professional executor cannot file the tax return unless they know all of the assets location. And when a professional executor works, they scour every bank. They scour Bank of Canada. They scour Equifax to determine where assets are held. And they also send a request to CRA at the very beginning to get copies of previous return to see if there's any income coming in from various sources. So when a professional executive is engaged, they do all the returns and they ensure that all assets outstanding are collected. Even assets that are dormant at Bank of Canada, they will discover because they will do the research to get it in.
Perfect, perfect. I'm going to try 2 questions because I know our time is coming up to 1 p.m. Eastern Standard Time. But I'll put them into you, Jandy and Rachel. So if I don't have a will, if I don't have a will and I don't have family in Canada, but I have family in another country, will the Canadian government take over my estate?
What happens, especially in Ontario, it will go to the PGT to say there is no one to administer this estate. The PGT oftentimes tries to find family members, so they'll do some searches, they'll hire a search company to see if there's even a remote family member in the country, or if a beneficiary resides in Canada, they'll approach them to see if they want to act. If there's absolutely no one, the PGT will act to settle the estate. But the family members who live abroad can petition to say, I want a professional executor to settle, and they can nominate a professional executor in Canada or nominate someone in Canada, a resident executive trustee that they want to act, but approval must be obtained from all of the beneficiaries. Sorry, I'm talking fast, but I'm running out of time. I apologize. If that person wants to contact me offline, I'm more than happy to go through some scenarios with them.
Perfect. And Jandy, one last question. Can your lawyer act as a professional executor?
Yes, you can nominate your lawyer to act. Keep in mind when lawyers act, the first question you ask is, what are you going to charge? Because you don't want your lawyer to charge the lawyer's rate to be an executor, because it will be a lot more significant than the executor's rate, because they're 2 different distinct roles, a lawyer and an executor. So if you want to use your lawyer, make sure you determine what the fee is going to be and enter into a fee agreement with them when you draft the will, so your beneficiaries will know what fees was agreed upon for that lawyer to act.
Perfect. Awesome, Jandy and Rachel. Thank you so much for that insightful presentation. I can't see our participants today, but I hope you found this session informative and answered some of the key questions on selecting an executor. So keep an eye on the next day or 2. We will send out this full presentation. I'm sure you need to review it and might have some more questions. And we're also going to include a survey that we love if you could fill in, because it will help us inform the next presentation, because we want to make sure we have topics that are of interest to our stakeholders here. So stay tuned for the next webinar. We're going to plan it for May 2026. Next year's not too far away during Leave a Legacy Month. I wish you all the best through the holiday season. Thank you for heading with us on our journey towards a world free of ALS. And have a great day and take care of yourselves. Thank you.
Thanks, everyone. Bye.